We'll hear from the appellant.
May it please the court, KB Battaglini for appellants who are sureties. This is a narrow appeal to a second review court arising from a memorandum opinion and order issued by a first review court, the district court, dismissing for statutory and equitable mootness appellants' challenge to and appeal of a portion of a bankruptcy court confirmation order. It was error, in our view, for the district court to dismiss for statutory and equitable mootness. Appellants seek a reversal of the memorandum opinion and order because the district court did not reach or consider the merits of the appeal. Appellants seek a remand for further proceedings on the merits and with instructions to, number one, determine the legality of the plan's non-consensual, non-debtor release of rights of recourse of sureties, and to craft relief that would not have significant adverse consequences to the reorganization, consistent with Highland Capital.
Do you agree that the plan has been substantially implemented?
That's not an issue. We don't contest that.
Okay, so your issue really is with 363M and how we interpret it.
363M would be the statutory mootness basis, and under MOAC, we believe that's no longer a credible argument.
Well, MOAC says something. You were reading a lot into it.
We try to rely on the language of the order itself, the opinion itself, and not expand what the court said. But it basically said it's not jurisdictional. It's not a jurisdictional provision.
Wherein, are you talking about the district court's ruling or Judge Isker's ruling? The word jurisdiction barely appears in the ruling that you're complaining about.
We appealed the confirmation order to the district court.
Right. But I'm talking about where is this reliance on jurisdiction? You're saying it's in the district court's order, correct?
Yes.
But he barely mentions jurisdiction. So where is it in the order that he's saying that this is 363M is a jurisdictional limit on what he can do?
Well, the district court plainly dismissed for statutory and equitable mootness.
Right.
The district court relied on our adversary's 363M argument. It did not address MOAC. It could have at the time, but did not address MOAC. We believe that MOAC clearly precludes the district court for dismissing for statutory mootness.
Well, MOAC was talking about whether a party could waive it or forfeit it, depending on your interpretation. And the court ends up saying it's not jurisdictional, it is waivable. We don't have that at all here, and I guess I've worked with your brief, I worked with the district court's order, and can you point to any particular part of the district court's order where you say that is where jurisdictional limits of 363M are being relied on?
I don't believe that the author of the memorandum opinion and order used those words.
Okay, so where does your argument come from to say that that's what the district court did?
By implication. There's no other explanation.
Well, if it's jurisdictional or if it's not jurisdictional, the statute says what the statute says, right?
Yeah.
So assume the district court had jurisdiction. How did it err by following the statute's language?
By following 363M?
Yeah, I mean, if everything in 363M is met, the prerequisites there, how did the district court err in upholding the bankruptcy court?
Because it dismissed on a jurisdictional basis, saying that under those directives of 363M, it could essentially not hear the case. That was a way out of...
Well, how do you square that, though, with the district court's reaching of equitable mootness? If it was truly a jurisdictional ruling based on the statute, the district court wouldn't have had the power to make the alternative ruling, would it have?
That's a good question, I think.
Well, I mean, doesn't that suggest, though, that the district court was just applying the statute?
I think the district court was applying 363M, but doing so improperly, giving MOAC. We argued MOAC even at that point. In other words, MOAC, we believe, is conclusive in its effect, and we argued MOAC, but the district court did not address MOAC, and we believe incorrectly ruled that the directives of 363M control without regard to the MOAC decision, which clearly says it's not jurisdictional. It could have directives, but that doesn't mean you can dismiss for statutory mootness.
But you could dismiss based on 363M if the other side raises the issue, right? And the statute's otherwise met. I mean, then it's not jurisdictional. And I'm thinking of jurisdiction versus claims processing rule. I mean, the difference seems to be that the jurisdictional argument can't be waived. It can be raised any time. It's never untimely. The court has to consider jurisdiction sua sponte. A claims processing rule can be waived, but here there's no waiver. The party raised it, and therefore the district court grappled with it. So, I mean, I guess I'm just struggling to see the error.
We didn't perceive that MOAC would be an issue in this appeal. We figured it would be conclusive, that the real struggle would be with equitable mootness.
That MOAC would be conclusive and that 360M would be off the table?
Yes.
Well, you may have assumed that, but I don't think the court's with you yet. So just looking at 363M, regardless of whether it's jurisdictional or not, again, as my colleague has said, and as I pointed out earlier, MOAC is talking about a party who consciously waived asserting it and then tried to inject it later. And we don't have that here. And so 363M, which you can probably quote better than I can read it, it says that the reversal or modification of an authorization will not be made on appeal unless there was a stay was obtained. You said you're not contesting whether the plan was substantially implemented. You're not contesting the things that are generally contested under 363M. So I'm wondering if we don't think this magic word jurisdiction actually controls the outcome in this case. Do you have anything to say about 363M and its inapplicability?
I do, and we briefed that extensively, but ultimately 363M does not preclude an appeal.
Well, no, you're here. We're not saying you shouldn't be here. We're just trying to figure out what relief, if any, you would be entitled to.
Relief vis-a-vis 363M?
Well, that's what the district court ruled on in addition to equitable mootness as an alternative.
Our position is that it no longer applies because of MOAC. It should be set aside.
It's not only not jurisdictional, it has no relevance.
Right. I think that's a good word, relevance. It no longer has relevance.
Is it being removed from the statute? Is 2011 U.S.C. no longer have 363M in it? It has no purpose?
Our view is that it has no purpose in dismissing on a statutory basis.
When would it come into play then?
Well, I didn't brief that. We didn't think that was necessary.
But I mean, I think the import of your argument, per Judge Southwick's point, is to render the statutory section a nullity, and I don't read MOAC to have done that.
We believe that it was enough to demonstrate that it no longer applies here because it's not jurisdictional, and that the real issue was going to focus on the equitable mootness.
Well, let's talk about that. How is it that the district court erred in finding this equitably moot? Because, I mean, I think this rests on a finding, does it not, that this provision, the full release and free and clear conveyance was integral to this transaction. It made the deal go forward. It was the basis of the plan. Is that a finding that we review for clear error?
Well, first of all, we don't believe the record supports that finding, but under Highland Capital, even if there was such a finding, it doesn't preclude an appeal.
But I'm not saying it precludes an appeal. How are we reviewing the issue on appeal? Is that a finding that is reviewed for clear error? In other words, is it a fact finding that the bankruptcy court made based on the evidence before it?
Well, this court is not going to review the facts.
We certainly do review facts, but we review them under a clearly erroneous standard. And that's what I'm getting at. Is this a fact finding?
We didn't ask this court to make a fact finding because this is a second review court.
Well, we're not going to make a fact finding, but we have to review the factual findings that underpin the bankruptcy court's ruling, right?
Right, and
What's our standard?
Our argument is there's no evidence to support that.
Well, you had the CEO of the, I guess, the purchaser who said, yeah, this was important to the deal. There also, I thought, was evidence in the record that the government wouldn't have approved this had this not gone forward.
Yeah, pure speculation as to the government. As to the witness, he testified after the fact, and he didn't really say what the district court's memorandum opinion and order says. That's in our briefing as well. The order went beyond his actual testimony. I tried to point out the distinction in our briefing. He didn't really say that the sale would not have closed.
Counsel, let me ask you, as a practical matter, if we were to agree with your position and rule in your favor, would that not, are you asking us to unwind the whole plan and go back to where the parties were? How can this be accomplished if we simply, how can we provide you with relief without significantly impacting the plan as it has been, as it was written, and as it now exists as substantially complete?
Pacific Lumber and Highland Capital are guides. In both cases, the Fifth Circuit acted as a first review court and actually struck the illegal provisions. Didn't upset the plan, it just took some words and struck them. We're not asking this court to do that because it's a second review court. What we are asking is a remand back to the district court for the district court to grapple with striking illegal provisions. We believe that that's the proper course here, is a remand for that to happen.
Let me also ask you a question about Section 363M. Can you point to any case, cite to us any case where a court found that simply seeking a stay as opposed to actually obtaining one was sufficient for Section 363M?
I think I cited some cases in my briefing. I don't have that handy in front of me.
But you think you cited a case that seeking a stay was sufficient?
Yes.
All right.
I don't recall that.
Well, we'll have to look at your brief.
Maybe it's in Highland Capital itself.
All right, counsel. You may proceed.
So appellants are actually challenging not the whole order. We don't seek to upset the reorganization at all. We are wanting to focus on some offending, what we perceive to be illegal provisions that preclude future rights of recourse of sureties against a non-debtor. And so that would apply to sections 18, 97, and 99 of the order. Section 18 is the initial offending provision that says all credit bid acquired interests shall be transferred to the credit bid purchasers free and clear of claims for reimbursement, etc., all of the rights of recourse. Claims, what does that mean? If these were merely the claims against the debtors, we wouldn't be here. That's not the issue. It's future claims, against a credit bid purchaser, a non-debtor. That's why we're here. Our adversaries take the position that this cuts off future claims against a non-debtor. Highland Capital clearly says that's illegal. That's why we're here. Our position is that the rights of recourse of sureties are both impaired and released. In Section 97 of the confirmation order, the court has certain clauses that are contradictory, but ultimately reached the conclusion that the provisions of cut off the rights of recourse of sureties illegally. So we the appellants objected to that as improperly authorizing non-consensual, non-debtor third-party releases, and the court, even in a hearing, acknowledged the contradictory nature, and this is part of our briefing, I cite the record, acknowledged the contradictory and ambiguous language in there, in Section 97 in particular, but nevertheless overruled our objections. Knowing that we would appeal, and the court acknowledged that we would appeal this, the bankruptcy court did, we sought a stay. The court denied the request for a stay, and we ended up in the district court where our adversaries immediately moved to dismiss for statutory and equitable mootness. We never had an opportunity to reach the merits. So this appeal is focused exclusively on the dismissal for statutory and equitable mootness and not on the underlying merits. We discuss the merits only for context.
All right,
We
counsel.
believe,
We have your argument. Thank you. Your time is up.
thank you.
May it please the court, Jessica Liou on behalf of appellees. This court should affirm the lower court's decision because Section 363M bars the relief that appellants seek.
Let me ask you, counsel, about one of the last things your friend on the other side was saying, that this case is about eliminating claims against non-debtors and future claims at that. How do you respond to that characterization?
I don't think that this case is about that at all. In fact, I think this case is about 363M. However, to respond to
Are there claims against non-debtors that have not yet ripened, if that's what he means by future claims, involved in this case?
No, we disagree with that characterization of what this dispute is actually about. What this dispute is about is claims that the sureties believe they have against the debtors, and somehow they want those claims for pre-petition activities that the debtors have taken to ride through and become claims that they can assert against a new entity that has come in to purchase assets free and clear under 363.
They're new claims because it's a new holder of the property, a new owner of the property? Is that why they're future claims?
They aren't future claims,
Well,
Your
no,
Honor.
just the characterization of it. But once you proceed, maybe I'll pick up better as you go through.
Yeah, I mean,
Well, are they not future claims because they existed before?
That's exactly
Sureties
right.
had this contingent liability.
That's exactly
If the debtor
right.
didn't fulfill its obligations to wind down activities and ameliorate environmental capital wells, those obligations that the debtor had, the sureties did a surety bond to make sure that happens, right?
Yes.
So the issue to me, I guess, is does that contingent liability carry forward, or, I mean, and the sureties would have recourse against various parties, I guess, if that came to pass, right? So now they don't.
That's exactly right. They're looking for an additional party against which they can assert claims for activities conducted by the debtor. This is the classic case of liabilities that should be left behind and were indeed left behind and resolved under the Chapter 11 plan
I think
that was
Judge
confirmed.
Southwick's point, so the current holders of the rights acquired from the debtors, would they be doing additional activities that could give rise to distinct new claims? In other words, would there be post-plan activities that would impact the sureties?
Yes, Your Honor. And in fact, the plan contemplated that to the extent that the purchaser engaged in new drilling activities, that they could be subject to potential subrogation claims on account of those new activities.
But does that not change the bargain that the sureties made with the debtor? In other words, they can't, and they didn't really count on somebody else coming in and doing different things. I mean, I guess they're doing the same things the debtor would have been doing, but
I think in any instance where a surety enters into a bargain with another party, there's the possibility that that party may at some point subsequently sell their property. In this case, this sale happened to occur in Chapter 11 with the protection of 363. And so therefore, I think it is entirely fair to rely on the statute and the bargained for consideration that the purchaser provided to allow the purchaser to buy these assets free and clear.
Counsel, is there any explicit indication in the credit bid purchase agreement itself that it was contingent on the release of the surety subrogation rights? Or is that something that we just get implied in the negotiations or Mr. Dane's testimony in the record? Is there anything explicit in the agreement?
Yes,
that we
absolutely. Absolutely, Your Honor. There are provisions in both the credit bid purchase agreement and also the plan and also the confirmation order in Section 1.1 of the initial draft of the purchase agreement, which was consistent all the way through all the versions, there was a provision that said that the assets were being sold free and clear of any and all encumbrances, and that only had a limited carve-out for permitted encumbrances, which did not include the subrogation claims of the sureties. As the bankruptcy court noted at the stay hearing, if you include a free and clear sale provision of all claims, interests, liens, etc., that's what it means. It's free and clear of everything unless there is a specific carve-out. In addition to the statements that Mr. Dane himself made when testifying about how the free and clear provision was paramount to the buyer in deciding whether to purchase these assets and contribute capital towards the reorganization plan, there were also statements made by purchaser's counsel at the confirmation hearing. He said in no uncertain terms, quote, "We can't stand by carve-outs from the free and clear provision." The future owners needed to know that they were purchasing assets free and clear and that obligations and claims somehow would not ride through, and that in particular, obligations under pre-petition agreements, including the sureties bonds that related to the assets, should not ride along and should be addressed under the plan as unsecured claims, which is exactly what happened here. In addition to that, I will point out that the entirety of the record itself supports the clear language and explicit language that was in the actual agreements. I'll note that for 5 days, the sureties repeatedly raised objections about how the free and clear language should include a carve-out for their subrogation claims. And not at once, before or after those objections were raised, did the purchaser indicate a willingness to proceed with the sale without full free and clear protection, including from claims asserted by the sureties. So at the end of the day, I really do think that the record supports here that 363M applies. And as this court has aptly noted, no stay, no pay. Where the party has failed to obtain a stay of an order authorizing a sale to a good faith purchaser, that failure is fatal to the appeal, and fatal means fatal. The court's only exception to this principle is when the validity of the sale itself is not affected by the appeal. But as noted by the record that I've just indicated here, this provision was integral to the sale. It was part of the bargained for exchange between the parties. And
how does MOAC affect the issue in your mind?
MOAC is a distraction. The district court exercised its jurisdiction to apply 363M and also find equitable mootness in this case. There was no issue of waiver, no issue of forfeiture here, and therefore it's not relevant to the discussion. Your Honor, I also want to point out that it's very clear from this court's precedent and also from the plain language of 363M itself that Congress has a strong preference for finality, especially here where purchasers are providing substantial consideration to purchase assets that are not laden with the risk of endless litigation as to who has what rights against the property that they're acquiring. The purchaser, in other words, here paid for the free and clear protections. And indeed, the testimony of Mr. Dane supports that the new owners wouldn't be making the investment that they are making and supporting the plan in the way that they are supporting it if they could not buy free and clear of the quote-unquote significant risk of potential claims from third parties. That was not the expectation of the buyer when they were buying free and clear. The purchase price here of $1 billion, including $225 million of new capital, reflected the purchaser's expectation that they would be able to purchase these assets without that overhang of the subrogation claims that could be asserted by the sureties. And
if we agreed with your opponent with regard to the 363M, do you agree that the proper relief from this court is remand for treatment on the merits, or is there something more that we would do that you think we should do?
Well, I don't agree, obviously, with what appellant is stating, but I actually think that there is no practical relief that the court could provide here. And indeed, when you posed the question to appellant's counsel, he couldn't give you an answer as to what relief would be appropriate here. They've spent a lot of paper and ink on proposing some kind of narrowly tailored solution here, but they haven't actually articulated what that solution could be, because that solution doesn't exist. That's part of the crux of why this court has developed a test to see whether or not provisions that are integral to the sale would end up affecting the validity of the sale. And because this provision was so integral to the sale, it actually does affect the validity of the sale, which, as we know from the record, was the catalyst for a series of complicated, interrelated transactions that ultimately culminated in the confirmation and implementation of a Chapter 11 plan that resolved $9 billion of asserted liabilities and P&A obligations, and included not only the formation of a new entity, the credit bid purchaser, to purchase certain assets, but the formation of multiple new entities through divisive mergers, the allocation of property to those entities, as well the funding of $50 to $70 million for working capital obligations, the funding of each of the wind-down entities, funding of $170 million of exit costs, and settlement agreements with no less than 4 different predecessors in interest, 2 equity rights offerings, entry into 3 credit agreements and a standby loan facility, and real property filings in 29 different counties and parishes and 100 mortgages. Also, the preservation of 1,000 jobs at the company. There were lots of transactions that cascaded from the initial purchase of these assets and the provision of the monetary consideration provided by the purchaser in order to support this restructuring.
Counsel, in this case, how does the analysis of equitable mootness really differ from the applicability of 363M?
Your Honor, I believe that there is substantial overlap in that analysis. And as a result, I do think there is an independent basis to support equitable mootness as well, from the record that we just covered. As you probably could surmise from the litany of transactions that I just recounted, there were numerous third parties that relied on the confirmation order and the sale. They have been, for the last 2 years, doing business with the purchaser and doing business with wind-down entities, including Fieldwood 1, Fieldwood 3, and Fieldwood 4. And those parties enter into contracts with these entities, including contracts that deal with the operation and decommissioning of numerous wells and platforms in the Gulf of Mexico. And in order to try to undo the sale, you would risk all these reliance interests of all these third parties that are completely innocent to the dispute before the court today.
Several circuits have discussed equitable mootness as a sense that the Fifth Circuit, through some opinions, is more lax on what that means. Has the Supreme Court ever endorsed equitable mootness in the bankruptcy sphere?
Your Honor, I think that what's relevant here is
I'm just
that...
asking a question. There's no trick involved with it. I'm just wondering, has the Supreme Court ever said we're on the right course with equitable mootness, or has it been silent? And if you don't know, that's fine. It's not necessarily something you would have thought about.
No, I have not thought about that in the context of this case, Your Honor.
All right.
With that, Your Honor, we would just ask that this court affirm the district court's ruling. If you have no further questions, I'll see the podium.
Thank you, counsel.
I was asked by the panel if I could cite some authority as to whether or not we could proceed even in the absence of a stay. And I have found it in my briefing. In Walker County Hospital Corporation, that's a Fifth Circuit case 2021, the creditor's appeal was foreclosed because it failed to seek the required stay, failed to seek it. In the 10th Circuit, Section 363M did not apply even though the stay was sought but not obtained, like in our case. So those are 2 cases that I had. Also in the Seventh Circuit, a failure to obtain a stay after seeking one should not be a censurable event to be punished by refusal to adjudicate the merits, especially in light of the Supreme Court's decision in MOAC. That's UNR Industries in the Seventh Circuit. That's in my briefing. So those are examples of stays being sought but not obtained, not precluding appellate review. As to the further inquiry by the panel regarding 363M and its applicability, 363M explicitly contemplates that appellate courts might reverse or modify any covered authorization. That's in MOAC. Section 363M's only proscription is that any such reversal or modification, quote, does not affect the validity of the sale, unquote. We're not challenging the validity of the sale. We're not seeking to upset anything other than offending language in one section of the order that a first review court, I believe, should strike for illegality. That's not going to change a thing. These notions that it's going to affect third parties, there's no record to support that. No record. It's speculation. It's, frankly, fear-mongering, if I may. .363M issues directions does not suffice to make it jurisdictional. MOAC. Consequently, as a matter of law, a district court is not deprived of jurisdiction to hear a bankruptcy appeal involving a sale or lease of property, even in the absence of a stay. MOAC. Article 3 appellate review of a bankruptcy judge's final order is constitutionally required. MOAC. No exception for exigency or finality exists. MOAC. That's why we believe that under MOAC, 363M is not relevant here. I'm speaking from the language of the order itself, not my take on it, not my interpretation.
Well, let me ask you what maybe is nothing different than what was asked earlier. But looking at the language, just to see how what you just said fits with the language of 363, reversal or modification on appeal of an authorization of a sale or lease does not affect the validity of the sale if the terms fit, good faith, whatever, unless a stay was obtained. So under your view of MOAC, what does 363M do? What effect does it have on an appeal if the terms of 363M are met? The sale can be set aside, or the sale terms can be changed, you're saying. Not set aside, you're making that distinction. You change the terms of the sale, but you don't set it aside. It's not free and clear anymore. Whether that's reversing or modifying the authorization of the sale or not, we can quibble with. But I'm just asking, what effect does 363M have in your mind if its terms are met after MOAC?
If its terms are met, if its directives are met?
Well, it sets out requirements for when this will apply. And I'm asking you, if all that fits, what is its effect after MOAC?
I think what's happened is that the Supreme Court has narrowed the interpretation. Over time, it was broadened beyond its scope. Now it's a more narrow interpretation that, in my view, no longer applies to this case, regardless of the directives.
All right, counsel, thank you. We have your argument. Thanks to both sides for helping us understand the complexities of what you have brought to us. We'll call the next case of the morning.